dog bite case in Florida that we're dealing with right now. So I represent the landlord in a dog bite case. They have renting a house out, a residential home in Florida. The renters have dogs, 2 dogs. My clients did everything right here. They vetted the renters. They did a background check, obviously. They knew about these dogs. What did they do? They asked for the type of dogs, the breeds, and then they went as far as to contact the prior landlord to ask if there had been any issues with these dogs, any dog bite, any sort of history with these dogs and animals. And of course, the prior landlord said no, they were great, well behaved, didn't tear up the property. Awesome. So my client did everything right here. So we're going to talk about in which cases are landlords actually liable for dog bite cases in Florida. There has to be 2 main things. There has to be 1, actual knowledge of the dangerous propensity of the dogs, which obviously we don't have here. And 2, there has to be the landlord has to have sufficient control over the property, which can be inferred, and most of the time is inferred, because landlord does have the ability to terminate lease if they do find out that there's dogs that they did not want, or they do find out that there are dangerous dogs on the premises. You can infer that they have sufficient control because most likely they're able to terminate the lease. So 2 things, and actual knowledge of propensity, dangerous propensity of the dog, and 2, sufficient control. Here they don't have actual knowledge, and we actually filed a motion to dismiss because the complaint doesn't even allege that the landlord has actual knowledge, which is a specific element that is required for the landlord to have liability here. Now, what is going to happen in this case? I don't know. I think obviously the renters did have liability because there's strict liability in Florida if you're the owner of the dog, and there already has been a settlement reached between the renter's insurance and the plaintiffs in this case who brought an action on behalf of a child. So there's been a settlement there. How long is the plaintiff and the plaintiff's counsel wanting to drag this on and litigate this regarding the landlord's liability when I think they know, we know, everyone knows there shouldn't be liability here? I don't know. So that's just something we have to play. We've done what's called a offer of judgment according to a specific Florida statute. If they don't accept the offer of judgment after 30 days, then they can be on the hook if we end up going to trial on this and they lose, or there's either no liability or the liability is the same as the offer of judgment that we gave, which was just a nominal amount. But the purpose of it is we don't believe there's any liability here. So if we have to go all the way through a trial and my clients have to pay me, they have to pay substantial attorney's costs and fees in order to go to trial, only for no liability to be there, then the idea is that the other party should have to pay those attorney's fees. So that's the purpose of that. So hopefully that gets the job done. We have our motion to dismiss set. I will update you guys on what happens there.
For the latest in case updates, legal tips, news, and politics, make sure to like us on Facebook, follow us on Instagram and our other socials, and above all, subscribe on YouTube to get your dose of excellence on a daily basis.